Hi, students. I'm back again. This is Unit 7. This is Chapter 7 of your book. The topic is self-incrimination. Um, this is week 12, and in week 12, this is the second part of the chapter. The topic is physical evidence self-incrimination. Week 11 was the first part of the chapter, was testimonial self-incrimination. So regarding physical evidence self-incrimination, this is regulated by the Fourth Amendment. Remember, testimonial self-incrimination, which is different, is regulated by the Fifth Amendment, privilege against self-incrimination. So we're talking about the Fourth Amendment here. So that's the source of protection from intrusion by the government when they're attempting to obtain physical evidence, self-incrimination. And there's two categories of evidence when concerning a person collecting evidence from a person's body. One is what we refer to as appearance evidence, and the second category is bodily evidence that is hidden from view. Appearance evidence is evidence exposed to public view. That includes things like lineups, photographs, measurements of height, weight, show-ups, fingerprints, handwriting, voice analysis, and failed sobriety tests. Those are some examples. There may be more. Those are just some examples of what we refer to as appearance evidence. So the authority to obtain this type of evidence corresponds to the type of contact a police officer will have with the person. So it goes back to the three types of police contacts that we discussed earlier in the course. So just as a review, there's three types of contacts. There's the least intrusive consensual encounter. It's not a seizure, but it has to be voluntary. Then there's a detention that's based on reasonable suspicion, which is a supposed to be brief contact, either to confirm or eliminate the suspicion. If it's eliminated, then the person is released. If it's confirmed, it's most likely going to lead to an arrest. And remember, the officer has to use what? Act expeditiously and use the least intrusive means to confirm or eliminate the suspicion. And then lastly is the highest level or most intrusive type of contact, which is an arrest based on probable cause, a high probability that the crime has been committed and that person committed it, then that person will be arrested for it. So obtaining the evidence corresponds to those three types of contacts. So when you want appearance evidence and you have engaged this person in a consensual encounter, if the person consents then and is voluntary, then that's all it takes, really. So if you have a contact with a person, consensual encounter, and you ask the person, well, can I take your photograph? Can I take your fingerprints? Can I measure your height, your weight? Can I record your voice? Can I take a video of you? And if the person consents, that's all it takes. So that's pretty simple. The next type of contact I mentioned was a detention. So the officer can use and collect appearance evidence during a detention if that appearance evidence is necessary to help the officer eliminate or confirm the suspicion. So let me give you an example. You have a robbery of a grocery store, a market, say, and the officer gets a call of that. An officer goes to the scene. A description's broadcast. There's other officers in the area, and they stop a person matching the description a few blocks away. So they have to confirm or eliminate the suspicion that that person is the person that robbed a store. And there's different ways to do that, but it's going to have to do with the person's identification. So, for example, maybe the officer will take a quick photograph on his cell phone and take that back to the clerk and have the clerk take a look at it. Or maybe they'll have a witness come to the scene and do a show up, take a look at the person. That is appearance evidence. It's the way the person appears, his body, his face, the way he moves, and so forth. So that is an example of appearance evidence during a detention. Another example would be if you had a suspect or suspects say, and you had a whole bunch of residential burglaries, and this person was in that area, and let's just say you had enough to detain this person, and you wanted to confirm or eliminate him from these burglaries. Well, if you had the equipment, you could fingerprint that person right there at the scene, and then you most likely let him go because later on you'd have to do the fingerprint comparison, which can take some time. But you could take those fingerprints and let that person leave, and then submit the fingerprints to the crime lab for comparison. And if they match, then eventually you could go arrest him on probable cause. You could obtain an arrest warrant and so forth. So that's some examples of collecting appearance evidence during the detention. Once you arrest a person, you pretty much control that person. So once you arrest him, you can collect all the appearance evidence that you need. So appearance evidence, I mentioned that already. And I've had this question is, well, you want the appearance evidence, but what happens, for example, if a person just refuses to do field sobriety tests, refuses to cooperate and have his fingerprints taken or his photograph taken or any other type of appearance evidence? What does an officer do about that? Does the officer force that? Well, not really. What happens is the person will become uncooperative, they will refuse, and that will be documented in the police report. And at trial, if it gets to trial, the jury can draw an inference of guilt from the person's refusal to cooperate and provide the evidence. So that's how generally that works. Um, so let's talk about bodily evidence. So when we talk about physical evidence, self-incrimination, physical evidence from the body, there's those two categories. There's appearance evidence, which I just talked about. Now I'm going to talk to you about bodily evidence. Bodily evidence consists of searching the suspect's body that's not exposed to public view, penetrating the body's surface to collect evidence, and removing biological and foreign substances from the body. There's different ways that that may come to be located in a person's body. Evidence may be hidden there, um, um, for example, when a person swallows something, contraband, or a person hides something in a body cavity. Um, for example, women might put it in their vagina or in their rectum. Typically, that occurs in institutional settings, but they can hide it in a body cavity. Also, evidence can be stored naturally, either temporarily or permanently. Uh, for example, alcohol, drugs, DNA, blood type, semen, and pubic hair. So this type of evidence is just naturally there. Um, well, alcohol and drugs not there naturally, but the other items are there naturally. But anyway, these items can be there naturally. Evidence can also be introduced into the body unnaturally. Drugs would be unnaturally. A person takes drugs or drinks alcohol, or bullets, for example. someone is shot and the officers need that evidence, then they would have to somehow obtain it through a medical procedure to get that. But all these, the procedures to get the bodily evidence are not routine. They're just not a routine type of collection of evidence. The more intrusive the means to get the evidence, there has to be greater justification. So these are generally highly intrusive. The need for it has to exceed the type of intrusion. There has to be a clear indication the evidence will be found. Generally the police have to have a search warrant, and they have to do it in a reasonable manner. Generally, it's going to require a medical personnel or somebody that's highly trained to collect that kind of evidence. So I said generally a search warrant's going to be required, especially for penetrating the surface, obtaining saliva, urine, semen, other bodily fluids, and pubic hair, manual inspection of rectal or genital cavities, and any procedure that causes pain or discomfort, or creates a risk to health or causes humiliation, you're going to have to obtain a warrant for that. Um, so also, there are times that this evidence can be collected not pursuant to a warrant, but pursuant to an exception to the warrant. Generally, the two that come to play are consent. So you ask the person for consent, or there's some sort of an emergency. So, for example, I've had cases where a person is taking contraband into a state prison. And a lot of times, the correctional officers already have that information. They have already generally have obtained a warrant, and so they will stop that person when they come to visit the inmate, and they will tell the person, pull them aside, tell them that they believe that they have contraband, and they ask the person to give them the contraband. So if the person consents, that's great. That makes it a lot easier. On the other hand, if they refuse, then the officers who have the search warrant are going to execute the search warrant. So they'll search the person, but in searching the person, they don't find the item, but they still believe the person has the item, and they believe that person has that item hidden in a body cavity. They will tell the person that they believe that the item is hidden in a body cavity and ask the person to produce it. If the person consents, that's fine. If they refuse, then generally what happens is the officers will seek a second warrant to search their body cavity. And generally that search is going to include authorization of medical personnel at a hospital to actually conduct that search, seize the item, and turn it over to the correctional officer. So that is an example of doing that. So they can do it by consent, or if they need a search warrant, they'll get a search warrant. I mentioned to you exigent circumstances. Remember, that's an exception to the search warrant. That has to do with an emergency. So what kind of emergencies can come up? Well, if you have a shooting, for example, and you have the suspect in custody, and when you shoot a firearm, a lot of times it'll leave gunshot residue on the web of your hand where you held the gun. Let's see if I can, right in here, right here. So you're holding the gun, you're gripping the gun, and there's gunshot residue in that area. And they want to collect that in order to establish that this person did in fact shoot the firearm. And there's a way that they collect that evidence from the body. So one way they could do is get consent, or it also can create an exigent circumstances because you have the person in custody and or detained, and you need to get that evidence. You may have to act quickly because that evidence is fairly fragile, and the person could be rubbing their hand to get it off. They may try to wash their hands to get it off. They might be wiping their hands on their clothing to get it off. So you can act under emergency circumstances to collect that information. Same with evidence under their fingernails. So you have a perpetrator involved in some sort of assault, and they have evidence under their fingernails, and you want to collect that, and you can act in an emergency if there's a risk that evidence will be destroyed by the perpetrator. So you have to be careful, because remember, as I mentioned before, when you're acting without a warrant, that search is presumed to be unlawful. The burden of proving it to be lawful is going to be on the prosecutor or the people. They're going to call you as an officer to testify, and you're going to have to be able to articulate that what you did falls within an exception to the search warrant. If the court concludes it doesn't fall within an exception, that evidence is going to be what? It's going to be suppressed. And that could be a critical piece of evidence to your case. So again, it's very prudent and wise for an officer to obtain that search warrant, because again, the search is presumed to be lawful. The burden is going to be on the defendant to show that it was unlawful, and that is generally a difficult thing for them to do. So anyway, those are the two categories of physical evidence, self-incrimination. There's the appearance evidence, which I talked about, corresponding to the type of contact you have, and then the bodily evidence, which is more intrusive. The evidence is hidden from view, generally going to require a search warrant, or it could fall within the exceptions I mentioned. But that's bodily self-incrimination. I want to talk to you about strip searching for just a moment. Strip searching, there's two types here that are involved. There's the post-arrest investigatory type of strip search. So you arrest somebody, and based on your investigation, you want to strip search that person. Can you do that? Well, first of all, there has to be individualized suspicion of evidence of the crime on that person, and you have to do it in a reasonable manner. So usually that means privately with an officer of the same gender. That's how you're going to do your strip search. So let's say, for example, you arrest a person for possession of drugs, and your information is that he has this evidence hidden and under his clothing. Do drug users and sellers do they carry contraband on them hidden from the officers under their clothing? A lot of times they do, or if they see the officer coming, they will place it there. They'll place it down in their underwear quite a bit, just to try to hide it, right? And so let's say the officer arrests that person, takes them to the station. They have belief that the person has that item hidden. They can do the strip search of that person, but it has to be private. It has to be by an officer of the same gender. So you can do it that way. And then also there's a different type of a strip search, and that's when the person is booked into a jail. Now, if the person is taken to jail, they're going to be searched. They're gonna take away all their personal property, their wallet, keys, and so forth. So they will take away their property. Can they strip search them? They can only strip search them if they're going to move them into general population. If they're going to move them in general population, they're actually going to take all their clothing and issue them jail clothing. If they're only going to be there temporarily, they're going to put them in a holding tank. For example, if you're a DUI, or if you're public intoxication, or they're going to cite you out on a warrant or cite you out for some other misdemeanor, you're only going to be there temporarily. They cannot strip search you. They can only strip search you if they're going to put you in general population, and take all your clothing, everything, and issue jail clothing to you. I just wanted to cover that so you know that. All right. Well, I hope class is going well. You're gonna be moving on to the 13th week soon. Anyway, I will look forward to posting another video lecture for you. Okay. Until then, take care, stay safe. I'll talk to you soon. Bye bye.